for something that happened 24 years ago. So, my lord, I have a slightly different issue. I'm not on this.
Whichever appeal is substantive, in your view, will take up first.
Sorry?
Whichever appeal is substantive,
My lord, mine is.
your perception will take up first.
Lord, mine is a very substantive issue
both
because
are
I was not a party.
By serial number.
Yes, I was not a party. And unfortunately, my lord, what has happened is in my absence, the learned judge has not condemned me beyond imagination. That's why I'm before your lordships. So, my lord, I am ultimately now, my lord, facing a prosecution. Learned judge has commented upon the merits of the prosecution and has left no remedy now available for me. So,
My
my
lord,
lord, I would like to show
in this
that.
matter, my lord, in 20.1 and 20.2, I appear, my lord, for respondent number 4 and respondent number 1 respectively. Your lordship may kindly see 20.2, my lord. All the only order that has been passed by the single judge in
Mr. It's my petition. Why do you want to interrupt just now?
is to
Mr.
simply
Raghavan, it's my petition. Please allow me. Do you have any preliminary objection or what?
yes, with respect to 20.2, yes.
Correct. By suppressing vital documents, these orders have been taken. I will show to your lordships.
Appeal will consider.
Sorry?
You are seeking leave to appeal.
Yes, my lord.
So we'll consider.
Yes, my lord.
Let the first main subject matter be addressed.
My lord,
your lordship may take up his matter first, brothers. Your lordship may take up his matter first. I'm in the first matter. Let that be done first. No problem.
my lord, I'm grateful to Mr. Singhvi. My lord, just turn to page, my lord, 88.
Which one?
Take up, my lord, 1713 of 2024. 20.1.
But all will travel together. We may take up first, no difficulty.
Yes.
But all three appeals will travel together.
Yes, of course. But my lord, I stand slightly on a different footing because I was not a party and I have suffered. My lord, one principle that has been settled.
We understand, but even then, all matters will travel together.
Of course, my lord, they will
as
travel.
far as the procedure and decision.
Today, I am more anxious than them because I am facing, my lord, this condemnation in my absentia.
All are appearing in your matter. All respondents are appearing.
My lord, they were.
Notice.
Your lordship.
Notice may
Last
have to
time, my
go.
lord,
Notice may have to
last time
go.
they appeared, Mr. Maninder Singh, Mr. Raghavan, learned Solicitor General, they were all there. I don't know which matter they appeared.
Notice is not at issue. Notice may have to go.
Yours,
Complainants are on caveat, my lord.
yours is 1713.
Yes, my lord. And 1719. Both.
But right now, leave to appeal is 1713.
Yes, my lord.
So who are the respondents? All are appearing. Then
Lord, they are on caveat. Yeah.
number 3 appearing.
Page 6, my lord, they are on caveat.
There are
The
six-
complainants.
6 respondents.
20.1, my lord, respondent number 4.
3, 4, 5 are on caveat.
Three, four,
Notice
five.
may have to go to respondent number 2, my lords.
I'm appearing for the state in this matter. I'm appearing for the state.
Appearing for the state.
State,
Number 1.
please.
But the notice will have to go number 2 and 5. 2 and
Mr.
6.
Tushar Smith had appeared before the learned single judge. Notice may have to go. My lord. Only after that, probably.
Lord, I am really not concerned about 17A order by the Excellency, the Governor. That's between them.
My lord is saying all must struggle together. That's in that context, my lord.
Only
Chief
thing that
Justice.
you may be separate.
Yes.
But at least in hearing part, we can't disconnect the things. That is what we are suggesting.
Lord, I would respectfully urge.
We'll treat you separate.
Yes, Lord.
You are separate.
Because, my Lord, I am getting dragged at the age of 80 in this, my Lord,
No, there is a-
slugfest.
There is a.
I have nothing to do with politics.
You remain Jal Kamalvat.
I asked my client whether he voted for BJP or Congress. He said, neither. I voted for Janata Dal. So, my Lord, why should I suffer because of all
So
this?
lotus
But
in
you
a,
have to
That's the
suffer-
reason.
You have to suffer because you are the Janta.
So, my Lord,
lotus in a water doesn't have the touch of water.
yeah, that's
So
true.
we'll keep you like that.
Very well.
But still it will be in the water.
Yes, yes.
So notice
Yes, my Lord.
Please.
which date?
Lordship, sir. Lord, I have one prayer. Lord, last time what happened, your Lordship knows by consent on 22nd it was adjourned. And everybody had agreed that learned single judge would be requested to Lord adjourn the hearing. Lord, my distinguished friend, Mr. Raghavan was not in the court before your Lordships. So before the learned single judge, he Lord stoutly resisted a request for adjournment. So it should be understood. Now learned single judge has kept it on 10th. Either your Lordships keep before 10th, I have no problem. Otherwise, my lord, if your lordships are unable to fix it before 10th, then your lordships may, it should be understood by all parties that matter. Otherwise, it will become infructuous, completely infructuous.
Why infructuous?
Sorry, because the learned single judge is now, my lord, post haste wanting to transfer the proceedings to
No, no.
CBI.
We do not.
That's the petition filed. That's what petitioners want. Learned single judge has issued notice on that.
How can you foresee a decision in any matter?
No, not foresee. The petitioners are insisting. Petitioners are insisting. So, my lord, I am respectfully submit. Either your lordships may protect me, or your lordship. It should be understood. I am in your lordship's hands.
My lord, can I make one submission? my
I am
lord?
seeking, my lord, ex parte stay today.
Can I make one?
Undoubtedly, because, my lord, I'll show to your lordships what wrong is there in learned single judge, which is hurting me very
Who are you,
seriously.
by the way?
My lord, I am a farmer who in 2004 sold this land to the Honorable Chief Minister's brother-in-law, not knowing what is going to happen in 2024.
Why you are?
Well, I've been, my documents have been set aside by the single judge. Single judge says I am party to fraud. Single judge says I am liable. Single judge says I should face prosecution.
Why you are so much bothering after this much years?
No, my lord, why?
It's not-
Why
it's
should
not-
I at this stage and age, my lord, face this? In
That will examine. But
Lord, my life and liberty is at stake.
what Mr. Raghavan is saying, yes.
My lord, can I make one submission, my lord? My lord, the anxiety that my learned friend is showing with respect to the hearing on the 10th is in 20.2. Please see the order that has been passed by the learned single judge against which this appeal is filed. All that the order says is, my lord, issue notice.
No,
It is
see the
against
last
that
order.
That is all the order that has been passed. Nothing more. I ask myself, how is an appeal maintainable against an order simply issuing notice by the learned single judge? This is all that there is in
Lord,
it.
see the last order, Madam Courtman.
Please see, my lord. Please see the order.
Kindly see the last order.
That is
Learned judge now has peremptorily fixed it.
That is 511 order.
No, subsequent order on 10th. 26, on 26.
My lord, what is challenge, my lord?
The understanding is matter would be heard on the said date. Now, my lord, they can't seek adjournment here. And kindly hear me on, my lord, ex parte stay. I'll pursue your lordships.
Sir, my lord, my objection is to the maintainability.
511,
I am
the
now
order was
saying,
that the law Ayukt is directed to place on record the investigation.
That's all.
conducted.
Yes, correct, but my lord, it affects me. I am talking about Article 21, my lord. Why should I be condemned without hearing? Lord, it goes to the root. There are 100 judgments of Supreme Court which says that if you have not been heard, it must be set aside. It's a simple thing, my lord. I'm praying to your lordships.
Only
Nothing,
the
my lord, big.
record of investigation conducted till particular date is ordered.
If this judgment qua me goes, this order goes.
There is no expression of opinion.
nothing.
No, nobody is saying. In this judgment, there is an expression of opinion.
My lord,
1713.
The matter coming
That
up.
is consequential.
No.
That is the second petition they filed.
Oh, you are saying that the proceedings may not go before.
Yeah, please see this, my lord. Kindly turn to page 88.
We are the least court to interject in the proceedings of other court.
I am not wanting your lordships to interject in other court. I am wanting your lordships to protect me here. Please turn to page 88. Let us see what the learned single judge has done. Kindly turn to page 88. I am only on my, my lord, case and why, my lord, I should be protected. Page 88, my lord. Please see the first issue. My lord, this writ petition was filed by the Honorable Chief Minister challenging the sanction granted by Honorable Excellency the Governor under Section 17A of the Prevention of Corruption Act. It had nothing to do with the complaint. Now see first issue that learned judge framed. Whether the petitions before the Governor and the complaints before the concerned court were justified in the fact situation. Page 88. Page 88, issue number 1. Whether the petitions before the Governor, fair enough, that was the subject matter before learned single judge, and the complaints before the concerned court were justified in the fact situation. Now, complaint is against me also, I'm accused for. I'm not a party here. Learned single judge without any necessity, because the issue only was whether Honorable Governor was right or wrong. Now please see finding at 232. And before I show other pages, please see 232, Lord, straight. Please kindly turn to 232. Summary of findings. I have been condemned, Lord. I have no remedy now. The complainants were justified. 232, Lord. First finding. Complainants were justified in registering complaint and seeking approval at the hands of governor, or seeking. Registering complaint. Now, which, Lord, trial court today will give me benefit? Now, see the findings against me at pages, Lord, 93 to 97 first. 93 to 97, Lord. Lord, I'll tell your Lordships briefly what happened. Lord, this is just kindly give me five minutes, Lord. Lord, this is a land which has been in my family since 1935. Lord, in 1968, Lord, this land was relinquished by me in favor of my other brother, my elder brother. Then it so happened that elder brother went into debts. And Lord, he passed away, unfortunately. His wife, son, and the other surviving brother, all of us agreed, appeared before the revenue authority in what is known as the inheritance khata, as my lords would tell. And Lord, the authorities recorded that my brother's widow, her son, and my other surviving brother have now relinquished the right in my favor. The land was accordingly transferred in my favor. All these facts are suppressed from the court, and suggestion is being made that although you are not the owner of the land, you sold it in 2004. Now, which is incorrect, because it is recorded on revenue and all the records are before your lordships today. I can show. Now, my lord, that happened. Then, my lord, the acquisition proceeding started. And before, my lord, in respect of my land, an individual award was made. I had moved an application for withdrawal of the acquisition under section 48 for denotification, which was recommended by a committee consisting of large number of members, including members from the Bharatiya Janata Party, Congress, Janata Dal, everybody in Muda. It was sent to the government. A committee of 6 secretaries of government of Karnataka considered that, and along with some hundreds of cases, denotified my land. I am not the individual alone who is benefited. Now, if that be so, then that denotification. Now, see at page 97, what does the learned judge say? Please see. Lord, after recording, and Lord, unfortunately, the petitioners did not inform the learned judge of full facts, although they got full record, but they selectively placed it before the learned single judge. So, Lord, I don't blame learned single judge for these findings. It's the petitioners who have misled the court. 97, Lord, just first at the top. Based upon the said proceedings, and notwithstanding the fact that the amount of award was also deposited before jurisdictional civil court. Now, Lord, civil court returned that amount, which they don't disclose. Civil court said that the amount is not deposited for individual plants. The land comes to be denotified. This, on the face of it, is illegal act on the part of the state. Now, Lord, denotification in my favor in 1998, learned judges commented in 2024. My right to property is seriously affected. It's a constitutional right under Article 300 capital A. And I have sold it for a valuable consideration under a registered sale deed in 2004 for 5,36,000 rupees. Now, my lord, please see at page 100. Please see. Page 100, my lord. First paragraph, last 5 lines. Mudda does not stop at that. Continues to form layout and distribute sites in favor of allottees. From 98 to 2003, owner of survey number 464 is shown as Mudda. Encumbrance certificate also reflects Mudda. Upon date of acquisition, it reflected name of Mallaraya, nowhere reflected name of Devaraju. Now, this is absolutely incorrect because, my lord, the land record shows my name again and again for various years. From 91-92, which was not, my lord. Here springs the picture, family of Chief Minister. I am not concerned, my lord. Devaraju, who claiming to be son of Ninja, para 21, executed a sale deed in favor of Mallika Jodnaiya. He is a brother-in-law petitioner. Sale deed is executed on 25/8/2004, but sites were found. Now, my lord, sale deed in 2020 years ago, who knows what will be the value in 2024? Learned judge says in 1935 value was 300 rupees. It is today 56 crores of rupees. My lord, how am I concerned as a small man? Now, my lord, please kindly turn to page 104. My lord, the learned single judge, please see at the 103 foot. What is discernible from the sale deed is none of the factors that have happened from 92 are even noticed. Devaraju was aware that subject land was included in preliminary notification. He was award final notification included. He submitted representation for denotification. Passing of the award is within knowledge. Deliberately, all these factors are suppressed and a sale deed is executed free from all history. But the land was already denotified. What is there to tell in the registered sale deed? Right or wrong? Nobody questioned it. And, my lord, your lordships are aware, my lord may perhaps tell your lordships, that in Karnataka, my lord, denotification is nothing new. Because, my lord, the farmers represent to the government and the government considers it. Now, my lord, right or wrong, in 1998, denotification took place. 1998. Now, all right, if you want to, my lord, damn me, at least the learned judge should have told the parties that join Devaraju as a party. So, my lord, without joining me, the learned single judge, my lord, has, now what is the, my lord, consequence? Show me that compiled, this note.
I don't want to interrupt my learned. I have a small suggestion.
Show me
But
this note.
this is a matter
Quickly.
in which, my lord,
It should have
your
ready
lordships, my
in
lords,
his hands.
consider it right or wrong. My lords. If your lordship decides to issue notice, then my lords, the matter will have to be heard. Right, my lords? Now, if your lordship don't want to dismiss it ex parte and issue notice, my lords, then let it be heard. Right, my lords? All parties should be heard at that point in time, my lords. Right? That's right. That's ideal. Therefore, my lords, we will all request the learned single judge because this has ramifications.
Kindly give.
Right. I'm sorry, my lord.
We will not come.
My lord, kindly see the law. My lord, your lordships are aware, but my lord, as recently as last week, I was sitting in Court of Justice, Dipankar Datta, my lord, and lordship set aside an identical judgment of the High Court where, my lord, observations were made and decision given against a party who was not before the High Court. Now, that law is settled, your lordships are aware. My difficulty is that I am a criminal complaint is filed against me. With these findings, my lord, the criminal complaint, I will have no defense left.
My lord, can I make one submission, my lord? The matter.
One second.
Yes.
All arguments of yours are liable to be considered on merits in respect to your prayer to leave to appeal, but not in connection with the staying of the proceeding to learn a single.
No, my lord, once your lordships grant me leave, I have a right to persuade your lordships to protect me. I am not, certainly, my lord, your lordships can't say that once your lordships grant leave, my lord, it's a right to appeal. And in appeal, I have a right to seek stay. Please don't drive me, my lord, from one court to the other. We are only respectfully urging your lordships that please don't.
All our jurisdictional courts. You go there and whatever you request there, we are not coming in way.
No.
As Mr.
Lord, please see this.
Sibal is trying to balance the things.
My lord,
What I'm trying to
my lord,
say,
the learned judge, my lord,
all parties, because this matter has ramifications, my lord, it's not just this matter, connected matters have ramifications.
Both of-
Right? So it should not be that the right to appeal is lost by some peremptory order passed by the learned single judge. That's all that I am, as a state, concerned about, my lords. Either way, I'm neither for, my lords, this side or that side. But my lord, therefore, there should be an understanding that
But we are in
till such
entirely
time
in
as
your
your
lordship's
lordship,
hands.
till
No,
such,
your lordship may
till
decline
till
me
such
interim.
time,
I have no problem.
this time, no, one second.
If
Till
your
such
lordships are
time,
not
all
persuaded,
parties should agree.
I am Lord, I can't Lord, go beyond that. I can only persuade your lordships.
No, no, I'm
Ultimately, I have to bow
suggesting-
down. I have to bow down to your lordship's decision. But I need protection because Lord, at 80 years, I don't want to face the criminal court. I don't want to face Lord, police and CBI. Why should I do it? I have nothing to do with them. I sold it. Lord, if today as a lawyer I sell land to somebody and 20 years later if it's found that he is into criminal activity, should I be held responsible?
My lord, can I make one submission if my learned friend will kindly
only-
permit me, my lord?
The only apprehension probably would be, my lord, is it fixed at 10,
That's
10th
right,
at
a
2.
peremptory order passed by him.
Can
Yes.
I, no, my lord, I
Everything in
will tell your lordships, my lord, what happened.
Raghavan, you should have joined me as a party. Why were you shying
One
away?
minute. Sir, I am not,
You didn't join me.
in which unit petition? I am not the petitioner.
No, you took, in your counter, you have made allegations against me. Despite the fact that it was governor's order, which was
I am
in
not the
consideration.
petitioner. Mr. Dave, I am
I will
not.
show your counter, Mr. Raghavan.
I am not the petitioner.
Serious allegations.
The petitioner is not me. The petitioner was Mr. Siddaramaiah. I was not
Petitioner
the
did not
petitioner.
do anything.
I was a respondent.
It was your counter which prevailed upon the learned judge.
Don't keep saying I should have made a party. How can I make you a party?
Mr. Raghavan, why are you not here today when we are here? I thought I would at least like to see you.
I would have loved to, but I had some other commitment which was a little unavoidable. Otherwise, I would have never missed being with you. And in the distinguished company of all of you, I would have loved to be there. Can I make one submission, my lord? If I am permitted.
Sorry, yes.